In this lesson, we're going to spend some time talking about the final type of mistake which can exist that can bring a contract to an end. This is, of course, the concept of unilateral mistake. And given the context of the previous types of mistake we've looked at, and given the name of this type of mistake, you should probably come to the conclusion that you know what this type of mistake essentially entails. This is the final lesson on the subject of mistake. We'll talk about, like I said, the final kind of mistake, this idea of mistake being unilateral in nature. Now, unilateral mistake pertains to those situations where, rather than both parties being mistaken to something, only one party is mistaken. Remember, common mistake was where both parties had a common mistake, i.e., they were both mistaken about the same thing. Mutual mistake is those circumstances where both parties are mistaken, but they are mistaken about different things. And then unilateral mistake, finally, relates to those situations where only one party is mistaken. In addition, the other party is aware of the mistake. And so a unilateral mistake will often take place in circumstances that relate to a contract where the contracting party's identity or the specific terms or the nature, finally the nature of the signed document is mistaken. So that there are mistakes in those kinds of circumstances. And I would like to draw your attention first to the 1878 case of Kundi and Lindsay. This was a case in which a fraudulent third party had written a letter pretending to be part of a firm and send a purchase order for handkerchiefs from the claimant. The third party was called Alfred Blencarn, and the firm he impersonated was Blenchiron Incorporated. The invoice was sent by the claimant for the order, and it addressed to the corporation, not the third party. The property was then sold on to a further defendant, and at which point we see a litigation taking place where the claimant sues the defendant on the basis of the tort of conversion. Now, because the identity of one of the parties was mistakenly thought to be Blenchiron Corporation, the courts determined that the contract was void on the basis of mutual mistake. As such, the claim for the tort of conversion by the claimant against the defendant was in fact successful. Another case that illustrates the idea of unilateral mistake more specifically is the case of Hartog versus Colin Shield from 1913. This illustrates the idea of mutual mistake, unilateral mistake, as it relates specifically to the terms of a contract. So this was relating to a mistake on one side relating to an offer which was to be put into writing. The defendants had been hide merchants who were in discussion about the specific sale of some items to that of the claimant. The discussion had amounted to the selling of hare skins. Specifically, it was 30,000 hare skins at 10 pence per skin, so quite a lot of hare skins, in fact. When the discussions had been more formally finalised, the terms were written differently. The terms were written as such: 30,000 hare skins at 10 pence per pound. Okay, so rather than it being per skin, it was then now per pound. So it was measured in weight, not in quantity. The shift in metric from 10 pence per skin to 10 pence per pound resulted in a significantly reduced final sum for the 30,000 hare skins. Given the fact that it was not relating to each individual hare skin, it was relating to the weight of the weight of the collective of the hare skins. In fact, it was a significant reduction given the weight of hare skins on average. The claimant wanted to maintain this lower price, as you can probably imagine, and so as a result of which sought to bring a claim to ensure that the terms that were written down had been adhered to. So the terms, essentially the dispute that existed here was in relation to the terms which were made vocally or made orally before the terms were put into writing, which was 30,000 per skim, 10 pence per skim. But then the dispute then arises when it comes to the claimant's argument that it should be the thing that is written down that is essentially adhered to, which is obviously 10 pence per pound. You can obviously understand why the claimant would want this to be advocated for, given the fact that they would be able to get 30,000 hareskins at a significantly reduced price than what was originally agreed before it was put into writing and formalized. The court held that it would have been clear the error on the part of the defendants by there would have been a clear error on the part of the defendants by the claimants, and so as a result of this, given that there was a unilateral mistake as to the term, and that this was known to the other party, and that nothing was said about this mistake, the contract was made void on the basis of unilateral mistake. So you have to make it very clear here that what clearly was the case was that the claimant knew that there was a mistake when it was formally written down in the contract, but they remained silent. They remained silent on that mistake because obviously that mistake would have incentivized them to get a lower deal and get a better deal and to maintain this better deal. So they thought, well, we won't say anything about the mistake that you've clearly made here because we want a better deal. It was concluded, therefore, that because there was a mistake as to the terms, and because the claimant knew about this mistake, but decided to say nothing, about it, because that meant that they would get a better deal, the contract was void on the basis of unilateral mistake. You can't really do that. It wouldn't be just or equitable for that to stand.